most of it has been covered. What's the aspect that really, my lords, what we have heard my learned friends argue, my lords, nobody has, to my mind, contested the fact that Section 35 has to be given play. That is not in dispute. I don't think anybody has contended that Section 35 has no role whatsoever in an arbitration or in a contract. The only question is, at what stage will it trigger? Will it trigger at an 11th stage? Or do we, my lords, if I can call it that, if I can call their argument the kick the can argument, my lord, that should be send it down to the arbitrator and then let the arbitrator or the arbitral tribunal deal with it. Now, my lord, the 11.6a point, my lords, as primarily Mr. Datar contended, my lords, was based on three facets. Because 6a, my lords, can be construed two ways. One is either what is the width of the jurisdiction that is intrinsic in 6a, or an efficacy argument, that it is not efficacious at this stage, we are delaying arbitration, that is not in the interest of ADR, etc. So let us send it down back to the arbitrator because anyway 16 has some kind of mechanism. I'll focus first, my lords, on the 6a part. Three aspects, my lords, that were highlighted in 6a. One, my lords, was the use of the word confine. It says confined to the existence of. The second part was existence, and some, my lords, emphasis was laid, my lords, on the non-obstante clause, saying, my lords, that because of that non-obstante clause, we should now, my lords, construe it to mean that other statutes or, my lords, earlier judgments have now kind of been diluted. Lords, for each one, my lords, I just give few references, my lords. As far as the width of 6a is concerned, post 6a, in fact, was interestingly in our case, I don't want to get into the merits of that curative, etc. Actually, 6a does not arise. Mine is an 11.6 case because the notice came earlier, etc., etc.
Before the other bench.
Yes. But in 6a, my lord, your lordships have consistently held that existence means validity as well. Consistently. I'll just give those references, my lord. I don't want to read them. Garware, my lord, which is at page 33 of volume 5a, para 29. In Drolia, my lords, which is page 73, volume 5a, para 153 and 154.4. And, my lords, NTPC versus SPML, that is page 1806 in volume 5a, at para 25, my lord, where, my lords, this eye of the needle test has been propounded, and, my lords, specifically held that the primary inquiry is about existence and validity. So, my lords, as far as that aspect of 6a is concerned, my submission is that validity is a, my lords, legitimate exercise under 6a, because Mr. Banerjee suggested, my lords, reading various authorities and the UNCITRAL, my lord, model, that perhaps it has to be a very restricted and narrow, my lords, approach to 6a, virtually, my lords, taking us back to pre-SBP and Konkan, etc. But, my lords, that has not been, my lords, to our understanding, the interpretation given by your lordships, my lords, even after 6a. Existence includes, my lords, validity. Secondly, my lords, as far as the notwithstanding argument is concerned, lords, the most detailed, my lords, in fact, there's a reference in Duro Pelguero, my lord, that the amendment in 2015, because the 6a comes in 2015, that it was intended only to overcome SBP and Bogara polyfabs. SMS was known to the legislature at that point. If the intention had been, my lord, to whittle down the scope of 6a and take out this dispute of stamp, my lord, there would have been appropriate language used. And, my lord, in Garware, my lord, because that contains the most detailed, my lord, discussion as to the legislative history of 6a, including referring to the Law Commission report, etc. Lordship may just note, my lords, paras 12 to 14, 19 and 22. And it is clear, my lord, that the legislative history was such that it only intended to take care, my lords, perhaps the legislature felt that as a result of SBP and Bokhara polyfabs, that too many issues were being gone into at the stage of 11 to restrict the scope. But, my lords, in my submission, my lord, that restricted scope does not take away, my lord, the fact that you can get into validity and therefore consequently this issue of stamping, which I separately deal with. But there's one thing I want to show, my lords, why the word examine, my lords, will or could, my lord, encompass the examination on the question of stamp. Kindly just have SMS, one paragraph in SMS, my lord. That is in volume 5A, page 8, at para 22.1.
Para?
22.1. The conclusion starts at 22. I just want to read 22.1. I'm sorry, it's page 16 of the running page, my lord.
Talking about volume 5A.
Yes, volume 5A, my lord. It's the second tab.
Page 16, not page 8.
At page 16, para 22.1. Starting at 22, my lord. May I read?
Yes.
We may therefore sum up the procedure to be adopted where the arbitration clause is contained in an agreement which is not registered, but compulsorily registerable and which is not duly stamped. The court could, before admitting any document into evidence or acting upon such document, examine, please note the word, my lords, examine whether the instrument document is duly stamped and whether it is an instrument which is compulsorily registerable. Now, my lords, the word examine, your lordship will find in 33(2) of the Stamp Act. That is the extent of the duty, my lord.
.33
33 subclause 2. The word used there is examine. But after the impounding, I'm sorry.
And one also says the court should, before admitting a document in evidence.
Or acting upon.
Yes.
Yes.
Read together.
Correct, no.
So here there's difficulty, one difficulty, we accept this proposition.
Yes.
If we accept that the arbitration agreement is severable, even if the parent contract or the underlying contract is held to be bad, is to be impounded, section 65 and 70, both restitution as quantum merit will apply.
Yes.
Cannot then it be argued that this issue can be gone into by the arbitrator as by a civil court?
Lord, the question, the severability, Lord, Mr. Diwan has a more elaborate argument on that. But
So quantum merits are decided by the
yes,
arbitrator.
they can certainly decide, but the question, Lord, the question is this. Lord, the question is this: the argument of severability, does it extend beyond the purpose in 16(1)(b)? Yes. Because our submission is not the purpose of the argument of severability is limited to that. It does not preclude, my lord. Yes. Why not? Of course they can, my lord. But the question is the court precluded under 11? Yes. No, not 35. Kindly see what is the language of 35. 35 first is mandatory. It says shall. There is no option there, really speaking. It shall and shall not act upon. Both. I'm sorry, my lord. No, but since your lordship mentioned about, the point I was trying to make is, I'm sorry. No, my lordship, sir. Now, Lord, 33, the point I was trying to make, my lord, this, the word used in SMS was examine. They were conscious, my lords, while making the amendment. The word used in 22.1, para 22.1 is examine. The language in the Stamp Act is examine. The language in 6A is examine. It is not, my lords, that there is any greater degree of inquiry that is required. So examine, my lords, will encompass. An examination is to whether a document or an agreement is properly stamped or not. Sorry.
Yes.
No, just three short points, my lord. Lord, the second aspect on section 5, my lord. Section 5, my lords, is not a bar. Because section 5 only says, my lords, notwithstanding under as per this part.
That Mr. Diwan made a point. He said
Yes.
the object of 5 was to prevent suits being filed.
Correct, my
to-
lord.
To delay arbitration.
But once there is
Once
there is a jurisdiction under 11 or the 9 or my lords 34 or 37, the width of that jurisdiction is not controlled by 5. Just one judgment, my lords. Your lordships may note it. I'll not, my lords. I don't have the time to read it, my lords. That's Chingtel's, my lord. It's in volume 5B, my lord. At page 547, sorry, 522. at, my lords, paras 38 and 39. At 547. That 5, my lords, will not control the actual width of the jurisdiction. Please.
I'm sure a lot of other states have this. Under the revenue law, under in Maharashtra, if a certain point arose before a civil court, you had to refer it to the revenue authorities for determination. What used to happen then is the moment you got the revenue authorities, everything then went into a series of procedural remedies, a revision, a statement of case, an appeal. So what the experience was that the entire process before the civil courts was stalled because until a finding was reached by a revenue authority, and exactly that's what's going to happen here. The moment we read the stamp act provisions to
Yes.
the 11.6a stage, the 11.6 stage, the net consequence is going to be that the entire gamut of remedies under the Stamp Act will have to be exhausted, and that never comes to an end. It goes on for years. and years.
There I have two submissions, my lord. One is, my lord, there is assumption implicit in this that the arbitral tribunal will handle it better. And that the arbitral tribunal will be able to control the stamp proceedings equally well. That's an assumption, I would say, with respect, my lord, because if the court is not able to control it, my lords, as your lordships are observing, lord, I don't.
Support control it. It's not.
No, it's not controlling. I'm that I'll deal with separately, my lord.
Less controls it more. So the intent of an arbitration act, very basic summary nature of proceeding 11.6. Why
Yes.
should we detain at the threshold?
And actually,
Whether they control it better, not control it better, the arbitrator to
No,
see.
lords, if the concern is,
the 2019 amendment, though not enforced,
yes,
gives us an idea about the mind of the legislature,
correct, my lord.
which is to continuously constrict or confine the intervention of the court at the
Yes.
first look stage
Yes.
by taking it away completely if the amendment were to be enforced.
Yes, my lords. Therefore, my lords, what we had suggested, my lords, kindly just have that the order of the judgment of the Delhi High Court in splendor, because, my lord, it sets out a whole scheme as
That
to,
we
my
have
lords,
made a point. We have made a
as
point.
to, my lords, how to control this.
Delhi and Bombay.
Faced with this constitution-made judgment,
They have to implement it.
whether everything should be left in a limbo or they devised a method, which you are right.
Actually, my lord, it's not a case of limbo, because they've actually devised a method to expedite it and control time frames. In fact, in the Bombay case, they found that the difference was 44 rupees.
But they were implementing the constitution bench.
Given that
It is work. It's a workable solution, is what I'm saying. What I'm suggesting, my lord, it's a workable solution. It's not a solution that can't work, my lord.
Thank you, Mr. Nair. Thank you very much.
Only one, sorry, I'm sorry, one last point was on this, on the question of, my lord, because of 35, it says for any purpose. In Avinash Kumar Chauhan, your lordships have said, my lord, if it is not stamped, unlike 49 of the Registration Act, it cannot be used even for a collateral purpose. That is, my lord, Avinash Kumar Chauhan is in volume 5B, page 104, at paras 22 to 25, page 110. I'm grateful.
I propose to take no more than 10 minutes. So that my learned friends will also.
What are your submissions, Mr. Diwan?
Was my
Are
first,
you now mentally on that side or are you still on this side?
so Milot, I have always,
Or you're
because I'm
simply
appearing for an
difficult.
institution, Milot, my difficulty, Milot, was as far as this, the challenge to the NN Global judgment, Milot, was this. We affirm NN Global, the 5 judges, on the basis that the doctrine of separability is limited and that the arbitration clause, save and except for matters under section 16, is part and parcel of the main contract. So to that extent, Milot, we affirm NN Global too. The little leg, Milot, which stands on that side, which is in fact a practical leg, is that under section 11, an arbitration need not be stalled if an arbitration agreement is inadequately or not stamped at all, or the main contract is not
The
stamped.
only point we are deciding.
Now, why is the doctrine of separability relevant?
But that is the only point we are deciding.
No, that's correct. In fact, your lordships heard Mr. Khambata at length on the doctrine of separability, where he suggested.
I've been saying repeatedly, and I think on behalf of people have gone here, there, in many places.
That's right.
We have repeatedly, I think, at cost of repetition, the Chief Justice, all of us have been repeating what we are deciding. If we've repeated what we are deciding, what's the point of saying, he said this, so I'm saying this,
I
or
appreciate
so-and-so said this, so I'm saying this.
Why is the doctrine of separability relevant? I won't take more than a minute to explain to my lords. If your lordships holds that today the parent agreement and the arbitration agreement are fused for all purposes save and except for section 16, then the challenge as far as inadequacy of stamping really goes to the challenge as far as the main agreement is concerned. And where there could be, where the level of stamping, the quantum of stamping becomes a matter of dispute. It's a matter
We are
which,
not really submitting before us.
because I'll only tell your
We are
lordships.
leaving it. The point is, if you are debating it, I agree, you have a right to say.
Right.
But we are not dealing with it. We have said so 20 times we are not.
Very.
We
My
are
only,
saying the only issue we are dealing with is, should at the stage, and Mr. Devan addressed it, he felt that no, at 11th stage itself, in the first blush, we should look into it.
Right.
Now there says, no, don't look into it. That's all.
because I have no difficulty, my written submissions are there. In case your lordships go into the doctrine of separability, my lords, my submissions are there that it must be restricted. That's one. Now comes the second point, and the only point that I will then address my notes on, which is in relation to section 11. Now, section 11, and whether, my lords, there should in fact, should an arbitration be stalled. My lords, if your lordships has section 33.
Are you
Of the Stamp Act.
on the, I thought you were on the side of the, this
On
side.
their side, I just have a,
Then there's nothing to add.
no, the only difference, my lords, is this. Mr. Datta seemed to suggest that a section 11 court could perhaps take evidence. He said, I'm not arguing that they can't take evidence. Mr. Khambata said, perhaps they cannot take evidence. My position.
They're not going to that.
Why do we have to go into these?
No, because of section 33 of the Stamp Act. And I'll tell your lordships why. If your lordships has section 33 of the Stamp Act, what does 33 set out? Because what 33 sets out is that every person by law or consent of parties, authority to receive evidence. So that's the starting point. Now, by my respectful submission is this. Once parties have chosen arbitration as a mechanism for resolving disputes, they have by consent under the Arbitration Act authorized the arbitral tribunal to be the body which receives evidence, and that becomes evident from section 19.
Thank you. That's exactly what I said before. You have a chosen judge, you have an arbitrator, the arbitrator will take a call.
And the consent. So therefore, my lords, as far as the second part of section 33 is concerned, it doesn't arise because by consent, you've said the tribunal receives evidence. Now, my lords, what about the first part? Every person having by law authority to receive evidence. Now, that is where, my lords, your lordships has to consider the Arbitration Act and section 11. There, my respectful submission, my lords, is this. Under section 11, your lordships is only appointing an arbitrator. Your lordships is not the court under 2(1)(e). That's the first point. Well, the purpose to what followed from the Honorable the Chief Justice, which is that all you're doing is examining the existence of an arbitration agreement. My respectful submission is that that power is constrained only to examination of the existence. Now, when a party comes to a court under section 11 and says, please don't act on the agreement because it is not inadequately stamped, that's not a dispute which goes to existence. Because the agreement exists. The party accepts that it signed the agreement in writing in terms of section 7. Because all that section 7 requires is an agreement in writing which is signed by the parties or perhaps exchanged in other forms. Now, if the agreement exists but cannot be enforced, then under section 11, the court has no power to go ahead and impound a document or even look into the Stamp Act. And therefore, in my respectful submission, really the way out, and that's really the end of my submission is this. The way out for the court is to say, we are constrained because we are not a court under 2(1)(e). The section 11 court has no power to receive evidence. If it doesn't receive evidence, it looks to see whether there's an arbitration agreement in existence. If it is, it refers the matter to arbitration. Because the defense is not that there is an inexistent agreement. The defense is not that I've not signed the agreement.
You are therefore supporting that submission.
To that extent, Manoj, I support that position. Manoj, that's the long and short of
Thank
what I
you,
have.
Mr. Diya.
Manoj, all of this has been set out in my written submissions, Manoj. I don't need
Thank
to
you, Mr.
address
Diya.
it.
I'm 707.1.
No, one second.